Hello friends, this is Sanjay. In this video series, we will cover the interpretation of statute subject from the LLB syllabus of Chaudhary Charan Singh University or CCSU, Meerut. The syllabus is common for both the 3-year and 5-year LLB programs. The complete playlist is available on the Lawment YouTube channel. While I have covered all the topics that are specifically mentioned in the syllabus, I have also included some additional concepts and topics which are required for a better understanding of the subject and also helpful if you are preparing for any post-LLB exams like the CLAT PG, UGC NET or Judicial services. The timestamps for the specific topics as per the syllabus are in the description below. This is part 2 and we will talk about the internal and external aids to interpretation of statutes. When you have to interpret a statute, the courts will make use of some internal and external aids to interpretation. What are these aids? Aids are things that help or assist in any task. For example, tools like a spanner or a screwdriver are the aids that you will use in repairing something. Or a calculator is an aid that you will use in solving a mathematical problem. So the aids to interpretation are all those things that help you in both interpretation and construction of statutes. Aids can be internal or external. All those things that can be found inside the statute itself are internal aids. We can also refer to these as parts of the statute. Everything else that can be used to interpret a statute but is not available inside the statute itself is an external aid. So everything inside a statute is an internal aid and anything outside is an external aid to interpretation. The first set of internal aids to interpretation are the title, the short title, and the preamble of the Act. The actual title of the Act can be a little lengthy. For example, the full title of the CPC is an Act to consolidate and amend the laws relating to the procedure of the courts of civil judicature. The title can usually help in understanding the main subject matter, the scope, and the purpose of the Act. Because the full title is lengthy, most acts will have a short title, which is the normal title that is used to refer to the act. As such, the short title does not have any significant value in interpretation. Some acts may also have a preamble, which will provide better context and also summarize the purpose of the act. The preamble of the Indian Constitution summarizes the main purposes of the Constitution, and it indicates the basic structure that should be maintained. The preamble of the CPC does not add anything significantly more than the long title. It just says that this is an act to consolidate and amend the laws relating to the procedure of the courts of civil judicature. How do the title and the preamble of the act help in interpretation? Well, both of these clearly specify that this act is applicable on civil courts only. So, if there is or was any confusion regarding the applicability of the CPC or any of its sections to any situation, we can use the title and the preamble for clarification. If it is a criminal case, CPC may not be applicable. If it is a civil case, CPC may be applicable. A point to remember here is that while the preamble can help us in understanding the objectives of the statute, it will not limit or extend the statute. If the provisions of the statute are already clear and unambiguous, the preamble cannot be used to change its scope. For example, if there was some section of the CPC which clearly states that this statute will not be applicable on specific type of civil cases, then the preamble cannot be used to override such sections or provisions. Headings, subheadings, and chapter titles are useful in understanding the objectives of that part of the statute, or that group of sections, or that chapter. In fact, they can be considered as the preamble to that chapter or that group of sections. Here again, the ground rule is that if the sections are clear and unambiguous, then the headings and the titles cannot be used to increase or decrease the scope of the sections. The courts have repeatedly ruled that the headings and titles should be used for interpretation or construction only if there is a doubt or ambiguity in the actual sections or provisions. In general, marginal notes are not given too much importance in the interpretation of statutes. However, they are useful in some situations. For example, if the words of a section are open to more than one interpretation, then marginal notes can sometimes be used to resolve the ambiguity or to reinforce an interpretation. Or if a section is very complex, then the marginal notes may be used to understand the overall context of the provision. Now here it is very important to understand whether the marginal notes were part of the original bill, which means that they were vetted and approved by the legislature, or they were added subsequently. If they were part of the original bill, it means that the legislature reviewed these marginal notes as well. So the marginal notes will have more importance. But if they were subsequently added after the Parliament passed the Act, then the marginal notes will have very minimal impact in the interpretation of statutes. If you look at the structure of some of the lengthier or longer central and state legislations like the Nyaya Sanhita or the Suraksha Sanhita, the document may have several components to make it easier to read and easier to reference. The statute may be divided into different parts. The parts may have different chapters. Like you can see that the Income Tax Act has different chapters. The chapters will have different sections. Some of the sections may have subsections. Some of the subsections may have clauses, and some of the clauses may have subclauses. This kind of a structure gives a logical flow to the entire document. But remember, it is not necessary to follow this complete structure. If it is a simple and a short statute, it may just have sections and some subsections. Sometimes a statute may start off with just sections. But when subsequent amendments are made, the subsections, the clauses, the subclauses may be inserted to change, to expand, or to restrict the scope of that statute. To explain how this structure works and how sections, subsections, clauses and subclauses are interpreted, I will give you a very simple example. Suppose a chapter in a statute talks about compulsory uniform to be worn by the students of a school. Then the sections may talk about pant, shirt and shoes, which are the different components of that uniform. In shoes, the subsections may specify that from Monday to Thursday only leather shoes must be used, and on Friday only canvas shoes must be used. And the clauses may specify that even in leather shoes only black and blue colors are allowed. Suppose students started wearing leather shoes of various shades of blue, such as sky blue, fluorescent blue, etc. Then the subclauses may be added to make this clause more specific, such as clarifying that blue does not mean any shade of blue, it can only be navy blue or dark blue. So by using subsections, clauses and subclauses, the law can become more specific and avoid any confusion or misinterpretation. For example, if a student comes to school on a Saturday and there is no specification mentioned here about what shoes to wear on a Saturday, then this statute can be interpreted in a way that even slippers or sandals are allowed on Saturdays. If the intention of the statute was that students should wear shoes on all days if they are coming to school, then such a clause should have been added, or they could have added a subsection for Saturdays and Sundays also. Right? But when it comes to pant or shirt, the statute doesn't specify anything about which day what to wear. So it can be interpreted that pant and shirt should be worn on all days if the student comes to school. You can also argue that since nothing is mentioned, pants and shirts are not mandatory on Saturdays and Sundays. So you can see that by using subsections, clauses and subclauses to make a section more specific, the possibility of ambiguity, confusion or misinterpretation can be avoided. This is an example from the Bharatiya Nyaya Sanhita. There is a section 2 that deals with definitions, and there is a subsection J which defines High Court. The clauses 1, 2 and 3 specify what all can be considered to be a High Court. If they wanted to make it more specific, they could have used some subclauses also. One of the basic principles of interpretation of statutes is that statutes should be read as a whole, which means that if you are reading a section, then you should also read the subsections, the clauses and the subclauses and interpret all of them as a whole. You cannot choose specific clauses, subsections or subclauses and interpret them independently. Definitions and interpretation clauses are very important since they define the terms used in the statute, and they help in significantly reducing the ambiguity about the application of the statutes. Definitions or interpretations can be restrictive or they can be expansive. For example, a restrictive definition may say that the term car means a four-wheeled car only, and an expansive definition may say that the term car includes vehicles with any number of wheels. So, cars with 3, 4 or 6 wheels are also covered by the statute. Illustrations are examples which show how the statute can be implemented. They are not part of the law itself, but they can help in explaining what the law means by showing how it might be applied in a real-life situation. Here, the illustrations are helping us understand that if A says this, then this is how the statute will be applicable. But if A says this, then this is how the statute will be applicable. Illustrations cannot increase or decrease the scope of a section. Exceptions tend to narrow down a broad general section. They specify situations when an otherwise general rule does not apply. For example, a statute may say that the speed limit for cars on a road is 80 km per hour, and the exception may say that the speed limit for three-wheeled cars cannot exceed 60 km per hour. So, the general 80 km speed limit will not apply in this exceptional case. Provisos are conditions or qualifications attached to specific sections in a statute. As we can see in this example, there are 4 provisos, which are stating situations where this section will not be applicable. Now you'll see that the provisos seem to be very similar to exceptions, because exceptions also state situations where a section is not applicable. So why are these called provisos and not exceptions? Well, there is a difference. While an exception narrows down the application of a general rule, a proviso carves out specific conditions. Using our car speed limit example, the section may say that the speed limit for cars is 80 km per hour. The exception may say that if the car only has 3 wheels, then the speed limit is 60 km per hour. And the proviso may say that this exception will not apply if the car is being used as an ambulance, which means that the proviso is carving out a specific condition when the section or the exception will not apply or will apply in a different way. So, to summarize, an exception will narrow down the scope, such as from 4 wheels to 3 wheels, and a proviso will refer to a specific condition or situation, such as when the 3-wheeled car is being used as an ambulance. And provisos typically start with the provided or provided that. Explanations are part of the statute and very important in the interpretation of sections. They typically clarify on the intent of the section, the meaning of the terms used, and how the section can be applied. An explanation can also expand or reduce the scope of the section. Here, the explanation to section 28 of the Indian Penal Code is clarifying that for something to be counterfeit, it is not essential that it should be an exact copy. The explanation to section 29 is expanding on the scope of the term document by stating that it does not matter what is the substance or the material used to write, or what is the substance or material on which the writing is done, and whatever may be the purpose, it will still be considered as a document. So, a document can be printed text on paper, or designs carved on a stone, or a photograph of something. All of them will be considered as documents under section 29. Punctuation marks are the symbols used to separate sentences or parts of a sentence, and also to convey the intent of the author. Full stop, comma, colon, semicolon, question mark. These are some of the punctuation marks used in English language. In the first sentence, there are no punctuation marks, so the sentence is not clear. It is also ambiguous because it can be interpreted in multiple ways. In the second sentence, the author is stating that he is going and he is asking the second person if he is coming. And this is clear because of the comma which separates the two parts of the sentence, and also the question mark at the end. In the third sentence, the author is stating that he is going and that the second person is also coming with him. He is not asking, it is not a request, it is a statement or a command. This is indicated by the exclamation mark. In the fourth sentence, the author is not sure about anything. He is asking whether he is going and whether the second person is coming. This is indicated by the question marks after each of these sentences. So, you can see that the meaning of the words changes due to the usage of the punctuation marks. In this example, you can see that there is no comma after or stocks and or exhibits, which means that this entire part, or stocks or exhibits or offers for sale, has to be read as a single sentence, which means that simply stocking something is not punishable, or simply exhibiting it is not punishable, but stocking or exhibiting something for sale is punishable. As such, punctuation marks are used for providing clarity on the meaning and intent of the sections, and punctuation marks cannot be used to arbitrarily increase or decrease the scope of a statute. Non-obstante clauses, which are also referred to as notwithstanding clauses, are used to establish priority or overriding effect over provisions or sections or even entire statutes. They usually start with the words notwithstanding, but they can also start with other words, like this one here, which starts with the words nothing contained in this section, which is also a form of a non-obstante clause. To explain this in a simple manner, let us use an example. If there are two provisions or sections or even two statutes that seem to operate on the same subject, then the non-obstante clauses can be used to establish priority. It is like if a section says you should listen to your teachers, you should listen to your relatives, you should listen to your friends, and then comes the non-obstante clause, which states that notwithstanding anything contained in this section, you should listen to your parents. So the non-obstante clause gives one rule or one law priority over the others, even if those other rules or laws might normally apply. In this statute, this section 9C is referring to a grievance redressal system, which includes a redressal committee. So it is evident that this redressal committee's purpose is to address the workers' disputes. There are also other provisions or sections in this Act that allow workers to raise grievances or disputes. Section 9C, subsection 5, is a non-obstante clause that establishes the priority of the worker's right to raise an industrial dispute under other provisions of the Act, even if a grievance redressal committee is set up. This clause is prioritizing the worker's rights over whatever is contained in this section. Saving clauses are normally included in new acts that are replacing older acts, or in repealing acts which are repealing an older act, either partially or fully. Saving clauses are intended to ensure that all the actions under the older act or any rights created under an older act are not rendered ineffective. For example, if an act gave industries in an area a 10-year tax holiday till 2030, but in 2026 a new act is passed that no longer has provisions for tax holidays. What happens to the tax holiday given under the old act and the industries that were set up to take advantage of the tax benefits under the old act? Well, this is where the saving clauses are added in the new act, stating that any tax holidays or tax benefits allowed under the old act will remain valid till their expiry. Conjunctive words are words that are used to connect two or more parts of a sentence or two or more phrases, and require all of them to be true for the overall statement to be true. Some common conjunctive words include and, both, all, each, and every. Disjunctive words are words that are connecting two or more parts of a sentence or two or more phrases and require only one of them to be true for the overall statement to be true. Some common disjunctive words include or, either, neither, nor, and none. For example, if I say you have to submit your PAN card and Aadhaar card, it means that both of them are mandatory because I'm using the conjunctive word and. If I say you have to submit your PAN card or Aadhaar card, then only one of them needs to be submitted and you can decide which one you want to submit. This is because I'm using the disjunctive word or. This section 149 is an example of the usage of a conjunctive word where subclause A ends with and, which means that both subclauses A and B are mandatory. This section 299 has examples of usage of a disjunctive word or, where the provision says this, or this, or this, which means that only one condition needs to be met. Schedules are supplementary documents attached to a statute to provide additional information or details that are not directly included in the main body of the statute. For example, the Constitution talks about the union list, the concurrent list, and the state list of subjects on which the union, the state or both can legislate. But the actual contents of the lists are not in the article itself. They are included in the 7th schedule, which is around 15 pages in length. Similarly, many statutes have schedules where they provide extra information that helps clarify and give additional details. Since they provide more details and are referenced in the relevant sections or provisions, schedules are normally considered as an integral part of the statute itself. If there is a conflict between the provision and the schedule, then the provision will have to be considered as authoritative. Annexures and appendices are similar to schedules in some ways. But the key difference is that annexures and appendices are usually not referenced in the sections or provisions, and they are more procedural in nature. For example, annexures may include things like forms or formats or additional instructions. Though they are not as important as schedules, annexures and appendices can still provide some context and some help in understanding the details of a statute. This table helps us get clarity on the differences between schedules, annexures, and appendices. Schedules provide detailed information or lists essential for the provision. Annexures provide supporting documents or technical specifications, and appendices provide additional information or context. Schedules are normally considered to be an integral part of the document itself. Annexures are not integral, and appendices are mostly supplementary information only. Schedules are normally referenced in the section or in the provision, like Article 256 of the Constitution references to the 7th schedule of the Constitution. Annexures and appendices are normally not referenced. So we can say that schedules are important in the interpretation of statutes, whereas annexures and appendices are not so important. We can start the discussion on external aids to interpretation with the historical background of the statute, which is usually available in the parliamentary reports on the bill before it became an act. The historical background tells us why the bill was needed in the first place and what were the steps that were followed to draft the bill, and also how it became an act. And all of this is quite helpful in understanding the true objective of the bill or the act. Historical background can also tell us if the statute is currently relevant or not. For example, if a statute was passed primarily to frame the rules to be followed while hunting tigers, and subsequently hunting is completely banned, then the old act is not relevant anymore. Another aspect that is connected with the history of a statute is previous laws on the same subject. For example, if we are looking at interpreting a provision in the Companies Act of 2013, we can look at the previous acts on the same subject. In some situations, an old law can help in closing gaps in the new law. Suppose that a new statute is enacted that prohibits the sale of alcohol to minors, and the new statute does not define what constitutes a minor. Then the courts can look at previous laws on the same or similar subject to see how this term minor has been defined in the past. For example, a previous law may have defined a minor as anyone under the age of 18. The courts could then use this older definition to interpret the term minor in the new statute. In this way, previous laws can be used to provide context, clarify meaning, and also fill gaps in the new statutes. When judges make a decision on a case, they explain their reasoning, and this explanation or reasoning can then be used as a guide in similar situations in the future. These are what we refer to as judicial precedents. In India, the principle of judicial precedent, also known as stare decisis, is a critical aspect of legal practice. A judicial precedent becomes mandatory for lower courts when a higher court has established a legal principle after deliberating on a matter. So, precedents set by the Supreme Court should be mandatorily followed by all courts across India, and precedents set by a high court should be followed by the courts that fall under its jurisdiction. Which means that if the higher courts have interpreted a statute in a specific way, and a lower court is faced with the same or similar questions, then the precedent set by the higher court needs to be followed. Legislative history is similar to historical background, but it is more focused on what happened in the legislative process. For example, why was the new law required? when was the bill introduced, what happened with the specific bill, what were the amendments to the bill before it became an act, what were the subsequent amendments made to the act. Documents like the Law Commission reports can help in understanding the legislative history of a statute, and it can help the courts interpret the true intent of the legislature. References to other statutes is quite self-explanatory. If you look at this example from the SEBI Act, it is making references to other acts such as the Companies Act, the Securities Contracts Regulation Act. Many statutes make references to other statutes for meanings, definition, context, and exceptions. This cross-referencing ensures that there is no ambiguity. And in a case of two statutes covering the same subject, one of the statutes itself will clarify which statute between the two takes precedence. All of you are familiar with dictionaries. They give us the meaning of words and also how these words can be used in sentences. There are also specialized law dictionaries that focus on legal terminology. Sometimes statutes include words that are a little unclear, or there might be a situation where there is a doubt on how a particular word should be interpreted. And dictionaries can be quite useful here. You can find plenty of High Court and Supreme Court decisions which reference to dictionary meanings of various words. The Supreme Court has observed that the dictionaries can always be referred to in order to ascertain not only the meaning of the word but also the general usage of such words. Of course, dictionary meanings and definitions should be used for understanding the common usage of the words only. Dictionary meanings cannot be used to change the context of the law itself. Foreign judgments may have persuasive value, but it is not mandatory for Indian courts to follow them. We can see court decisions referring to foreign judgments, especially judgments from common law countries, whose judicial systems can be traced back to the British legal system. Foreign judgments are often used in situations where a particular statute has been written using a foreign statute as a base. For example, there are several features of the Indian Constitution that are based on the constitutions of other countries. So, if there is a question around interpreting such articles, foreign judgments can be used to persuade the court. Foreign judgments can also be useful where a foreign law has the same or very similar objectives as an Indian law. For example, the data protection laws of Europe have similar objectives to the Indian data protection laws. So, foreign judgments that interpret the foreign law can be used by the courts as an example. In this example, there is a reference to a decision by the American Supreme Court and how that principle of law is accepted by the Indian courts. Treatises and commentaries are legal books written by experts on a particular topic. They may be new books, old books, or even ancient books. In this example, you can see that there is a reference to Maine's treatise on Indian law, which in turn refers to much older manuscripts on Hindu family law, such as the Dharam Sindhu, Samskar Kaustubh, Dattak Nirnay, Dattak Chandrika, and Dattak Mimamsa. Treatises and commentaries have been used mostly in interpretation of family laws, where the current laws may be derived from ancient customs and traditions. If you go to the Parliament website, you will see that all debates are recorded and available for review. Now, when a statute is to be enacted, it is presented in the Parliament as a bill, and it becomes an act only after the approval by the Houses of the Parliament. During the approval process, there would have been some discussions or debates on the bill. Some questions asked by the members of the Parliament, answers and clarifications on those questions, etc. Subsequently, if there is a question around the interpretation of that statutes, the courts can also refer to the parliamentary debates for clarity on the legislative intent. What did the makers of this law want to achieve through this law? Some statutes, like the Environment Protection Act and the Human Rights Act, are based on international conventions and agreements. In fact, the acts themselves mention this clearly. The Environment Protection Act is based on the United Nations Conference on Human Environment, and the Protection of Human Rights Act is based on several international covenants that India is a party to. So, if there is a question about the interpretation of such statutes that are based on international law, covenants or agreements, then the origin or the source itself can be used as a reference to understand the intention and the scope of the Indian law. Of course, it is not necessary that India has to agree with everything that is mentioned in the international convention or agreement. So, the courts will also refer to the Law Commission reports, parliamentary debates, and other documents to interpret the law in the Indian context. To ensure uniformity in the interpretation of statutes, there may be references to the General Clauses Act. The General Clauses Act provides uniform definitions. For example, the meaning of the term regulation in the CPC will be the same as in any other statute that uses the term, if they all refer to the General Clauses Act. The General Clauses Act provides uniform interpretation rules and standard legal procedures and formalities, such as a standard for the computation of time. Like, what does it mean when a statute says something has to be done within 1 month? Is it 28 days, 30 days, 31 days? And the General Clauses Act can also provide a clear definition of the powers and functions of authorities. So, the General Clauses Act is an important aid in the interpretation of statutes. The courts will have to consider social, political, economic, and scientific developments while interpreting statutes. For example, when the original telecommunication laws were written, telegraphs were being used commonly. So, the laws were mainly written to cover the transmission of the written word through a wire. Then came telephones, which brought in transmission of the spoken word, that is, voice, through a wire. Then came mobile phones, which meant transmission of written words, that is, SMS, and also the spoken word, wirelessly. Then came smartphones, which meant transmission of written words, voice, and also electronic documents through the internet. So, the telecommunication statutes had to be interpreted after taking into account the scientific and technological developments of the specific time. Then comes the Constitution of India. This is something I have previously covered in the Constitutional Law series. The Constitution is the primary rule book of the country. All procedures and guidelines that we see in public and private institutions are based on various rules and regulations. These rules and regulations are based on various central and state legislations. And all the legislations in India must adhere to the broad framework provided by the Constitution. For example, no laws or statutes can contravene the fundamental rights guaranteed by the Constitution. The powers of any authorities cannot exceed the limits set by the Constitution. So, whenever there is a question of the interpretation of any laws, especially if the law seems to be interfering with fundamental rights or constitutional rights, or seems to be in contravention of any other article of the Constitution, then the Constitution itself should be used as an aid to interpretation. Travaux préparatoires is a French term that simply means preparatory works. This term is mainly used in the context of international treaties. It simply means that when interpreting an international statute or a treaty, we should look at the negotiating history, the drafting history, and any reference documents that were used during the drafting and the discussions about the treaty. These are nothing but the preparatory works done before the treaty was signed and agreed. Article 32 of the Vienna Convention on the Law of Treaties talks about supplementary means of interpretation. It says that if the plain language of a treaty is ambiguous or obscure, or if the normal interpretation of a treaty based on its plain words is leading to an absurd or unreasonable meaning, then supplementary means of interpretation, including preparatory works of the treaty, can be used for interpretation. As I mentioned earlier, this preparatory work is nothing but travaux préparatoires. Pari materia means on the same subject or matter. So, statutes in pari materia means statutes that cover the same subject or same matter. For example, the Indian Contract Act and the Sale of Goods Act both deal with contracts. So, at a higher level, they have the same subject. The Code of Criminal Procedure and the Indian Evidence Act both deal with criminal law and procedure. So, at a higher level, both of them have the same subject. A point to remember here is that if we go into the specific details, then these statutes address different aspects of the same subject. While the Indian Contract Act covers a wider range of contracts, the Sale of Goods Act is more focused on contractual transactions associated with the sale of goods. The basic idea behind the principle of statutes in pari materia is that if there are two statutes covering the same or similar subject matter, then they should be interpreted in the same or similar manner. For example, you cannot have one rule for general contracts under the Contract Act and another rule for contracts under the Sale of Goods Act. Otherwise, there will be contradiction and confusion. So, statutes covering the same or similar subject should be interpreted in the same or similar manner. To identify statutes in pari materia, the Delhi High Court specified some tests in its decision in the Rais-uz-Zama versus State of Delhi case. It said that if two or more statutes have been given a collective title, like criminal laws or contract laws, then it signifies that the set of statutes are in pari materia. Or if two statutes have to be construed as one. For example, the Companies Act and the Companies Amendments Acts have to be construed as one act. Then such acts are in pari materia. Acts having short titles that are identical, apart from the calendar year. For example, the Finance Act 2020, the Finance Act 2021, 2022, 23, all of these have identical titles except for the year, which means that these statutes are in pari materia. Even the Companies Act 1956 and the Companies Act 2013 are statutes in pari materia since they have the same title but different years. Different acts that deal with the same subject matter on the same lines, for example, the Industrial Disputes Act and the Trade Unions Act, both relate to labor relations and workers' rights. Both contribute to the framework governing industrial relations. Therefore, they are statutes in pari materia. The Sale of Goods Act and the Consumer Protection Act both deal with the rights of buyers and sellers and warranties and other conditions regarding goods. Both acts are designed to protect the interests of the buyers and sellers in the marketplace. Therefore, they are in pari materia. With regards to how to use this principle of statutes in pari materia in interpretation, the Supreme Court has provided clarifications in various decisions. Two statutes dealing with the same subject matter must be interpreted harmoniously. The language of one statute can be clarified by referring to the other statute in pari materia. And the doctrine of pari materia applies even when the statutes are not in pari materia in every respect, that is, they are not exactly same. India has many laws that were originally enacted during the British Raj in 1836, 1842, 1850, and many of these statutes are still valid, even though they are more than 150 years old. Contemporanea expositio is a principle of interpretation that is useful in situations where the court is dealing with such very old laws. This term is a Latin phrase which means contemporary exposition. The basic idea here is to interpret a statute by understanding the social, historical, and linguistic context in which the law was created. That is, we have to look at the contemporary factors when the law was originally created. This will help us understand the legislative intent behind the law and why it was created. For example, if there is an old law which says that the speed limit for vehicles in a particular area is 20 km per hour. When we look at the contemporary situation when the law was enacted, it could be that there were no motor cars at that time. The term vehicles in that old law referred to horse-drawn carriages. Or if the rules for an exam say that no calculators allowed, and these days people don't use calculators much at all since we use smartphones. So if we try to implement the rule as is, it will lead to an absurd situation where calculators are not allowed but phones are allowed, which are more powerful than calculators. By looking at the contemporary situation when the law was created, we can understand its original intent. What was the mischief that the law addressed? The court can then decide whether the law is currently relevant or not, and how the law can be enforced in the current situation, and what are the changes that may be required to make the law suitable for the current society. In some landmark cases, the court has emphasized that when interpreting old laws, the state of affairs prevalent when the law was enacted should be taken into consideration, and also that this principle is more of a guidance and not a rule. If the words of a statute are clear and unambiguous, then it should be enforced as is. If you go to the Ministry of Home Affairs website, you will see that there is a section containing reports by various judicial commissions or inquiry commissions. These commissions are appointed by the government or by the courts when there is a need for a thorough and independent investigation into a specific serious issue or event, especially those which affect the interests of the wider public. For example, there is a report here by an inquiry commission looking into the issue of illegal mining in the state of Jharkhand. If a court is dealing with this specific case, then the inquiry report provides a better understanding of the situation where the statute needs to be interpreted. For example, when the Bhopal gas leak happened, it was one of the world's largest industrial accidents, and probably none of the laws that existed at that time were designed to deal with such a situation. So, in the cases involving Union Carbide, the Inquiry Commission reports provided a better understanding of what actually happened and how people were affected in the short term and in the long term. That way, the Inquiry Commission reports helped the courts in interpreting the law to deal with this unprecedented situation. Similarly, in the 2G spectrum case, the Inquiry Commission reports provided clarity on what the issue was all about. How are the procedures and policies violated, and how the laws need to be interpreted to address the situation related to telecom licensing. The Law Commission of India is a non-statutory body that is constituted by the Government of India under the aegis of the Ministry of Law and Justice. The Law Commission primarily conducts research on various topics in the field of law, and the Commission makes recommendations to the government. These recommendations may be for creating new laws, for amending existing laws, for scrapping old laws, or for reviewing the interpretation of various laws. The normal tenure of the Law Commission is 3 years, and during this period, they can submit several reports on various topics. You can find all the Law Commission reports on their official website. For example, this report number 274 was one of the 15 reports published by the 21st Law Commission. And this report is a review of Section 2 of the Contempt of Courts Act. If you look at the contents of the Law Commission report number 274, it is a very elaborate and comprehensive document. It starts with the history of the concept of contempt of court in India. It looks at the existing provisions which address this mischief. What is the international scenario? What has been the judicial approach on contempt? What is criminal contempt? What does not amount to contempt? And the conclusions and recommendations that can be drawn on the basis of all of these. These recommendations may have led to changes in the policies or procedures, or even changes to the law itself. When a court has to interpret a statute to deal with a situation involving a contempt of the court, these Law Commission reports provide a comprehensive background on the topic and the associated statutes. In the Aadhaar case, the court referred to multiple Law Commission reports that touched upon the privacy implications of Aadhaar. In the Triple Talaq case, the court referred to reports that focused on family law reform. In the Vishaka Guidelines case, the court referred to the 84th report that addressed the key issue of the case. Another interesting aspect is that over the years, several Law Commission reports have covered topics related to interpretation of statutes as well, such as the need for clarity while drafting laws, the usage of legislative history as an aid in interpretation, the basic principles of interpretation, the importance of considering the original context and purpose behind a statute, the usage of the General Clauses Act for interpretation, and interpretation issues in the context of evidentiary laws. Therefore, we can conclude that Law Commission reports are a very important external aid to statutory interpretation. India does not have a national language, but there is a concept of official languages. An official language is used for official purposes by the legislature, the executive, and the judiciary. If you look at the various states and the union territories, they use many languages as their primary and secondary official languages. The language spoken by the majority of the people in that state is usually the primary official language of the state. Apart from the 22 official languages listed in the 8th schedule of the Constitution, some of the states also use other languages like Bhojpuri, Nepali, etc. The central government uses Hindi as the primary official language and English as the secondary official language. The Supreme Court uses English as its primary official language but allows the use of Hindi in specific situations. The High Courts mostly use the official languages of the states where they are located and also English. When central legislations are published, they are usually available in Hindi and English only. The Official Languages Wing of the Central Legislative Department provides official translations of some of the important statutes in some of the other official languages of India. But not all of the statutes have been translated. The states will also have their own department or directorates that also provide a translated version of central legislations in the official languages of the state. For example, the Karnataka government's Directorate of Translations provides Kannada translations of most central acts. Some rarely used acts may not have been translated, or some very new acts may still be in the process of being translated. In such cases, unofficial translations may also be available. So, while interpreting a statute that is not in the language of the state, the unofficial translations of the statute may be used only for reference and for better understanding, because they are not authoritative. The official translations provided by the state government's translation department or the Central Department of Official Languages are more authoritative and can be used for interpretation. If any question or doubt arises while using these translations, then the original versions of the statute in Hindi and English should be used as the most reliable versions. If there is a contradiction between the Hindi and the English versions of the same statute, then the courts can evaluate on which version best represents the will or the intent of the legislatures and interpret the statute accordingly. And with that, we can conclude this session. If you have any questions or feedback, post a comment below. I will see you soon in the next video. Take care and Jai Hind.